that we will start at 11 itself. So I've just unmuted you.
Yeah.
Yeah. So we have 3 minutes to go. Then we start the session.
Yeah.
Yeah.
You have unmuted, right? 3 minutes to start the session.
Meanwhile, you can just, if you want, you can just give us a brief what you intend to speak.
Pardon?
Brief background, what you intend to speak till then.
Brief background.
Yeah.
You may kindly see the topic itself states that the Constitution and its dynamics. So how the Constitution is functioning essentially now. How the Constitution is divided into number of parts, and who are the players, who are the stakeholders. It is impacting on the public, and what sort of protection it is giving to the citizens. We may have to, I may be taking you several important, to my mind, articles of the Constitution and the latest amendments in the Constitution, at least 3 to 4 amendments, which is welfare oriented and one important substitution made in the Constitution, and moreover some suggestions regarding some amendments to be made to the Constitution. This will be my attempt. I hope you are clear.
Yeah. Before we start, how was your experience while you argued the matter of Navtej case?
Navtej, it was quite interesting. And I have argued the matter before the division bench, Justice Singhvi and Mukhopadhyay. And that judgment was rendered in favor of the people and party whom I argued. That is 377 should be there. That was a contention advanced. And now the matter sailed before the 5 judges bench in the form of Johor. And that was also an interesting experience. The Supreme Court, to my mind, was very kind and benevolent to the people who were suffering. That's what happened. Now I'm told that certain review petitions have been, accuracy petitions have been filed. It's a dynamic approach that is that has been adopted by the Supreme Court, to my mind, and very comparative.
Taking a different perspective, giving the Constitution and all a different, altogether a gist and way forward to think.
Absolutely, absolutely. It's a law is properly cut out in the changing society. That is how I feel. And to accommodate and to bring these people into the mainstream of life, and to give them respect and dignity, which to my mind is taken care of, or rather one of the preambular concepts in the Constitution, dignity of every individual.
And so, what was your take after that Sabrimala's case? Before we go to the session, we just wanted, let's have the insight of your all, what went behind all these judgments, what was your experience, what was your journey?
That was a brilliant case. I mean, spiritually viewed. And what is institutional morality, and what is the disposition of the Lord Almighty, and whether people who do not believe can bring in a public interest litigation rather to decimate one of the aspects of the faith of the religious community. another religious community, if I may say so. So it was argued in a very cordial manner, in a pleasant atmosphere. All the views were taken, but unfortunately, the 5 judges bench held that the women can be allowed to entry, that is the prohibited age group, 10 to 50, can be allowed to have darshan, which to my mind goes against the religious freedom guaranteed under Article 25 and 26 of the Constitution of India. And unfortunately, there was a mixing up of Article 17 judgment. Article 17 stands on a total equality. I mean, 14 to 18 cannot be allowed to detrimentally affect Article 25 and 26 of the Constitution. So now the matter is pending before the 9 judges bench. After Justice Gogoi pronounced his judgment, now in view of this particular, whether it is having the space to accommodate all the 9 judges. How the lawyers can be, because usually it used to be a crowded court in the Chief Justice Court when these matters are being argued. So that is the situation. Anyway, one is looking for
Mr. A. Radhakrishnan doesn't require any further introduction. He has been one of the brilliant lawyers who has been associated with all matters which are of constitutional importance. All lawyers and the students would be enriched by your knowledge, for the fact that invariably large number of lawyers, even though they are practicing on the constitutional side, primarily they are believe that constitution is primarily based on Article 14, 16, 19, somewhat nowadays 51, 300. But after your knowledge, once you speak, we will have a matter which will have more things to have a food for thought in the mind and the heart. So over to you. As per our platform, 50 minutes, around 40 to 50 minutes, we will ask for your thoughts. Then there will be Q&A session for around 30 minutes. So the session will be up till 1:30 or 12:30. So over to you.
Right. I can start.
Yeah.
Thank you. Good morning to all. And I wish everybody that by the grace of the Lord Almighty, all of you are having very good health, both physical and mental. Now today, we have to have a talk on Constitution and its dynamics. Kindly see, the Constitution of India has been framed, and we the people of India have resolved to constitute this republic in a particular form, that is sovereign, socialist, secular, and democratic republic. This is for the purpose of an orderly living of the people, healthy, wealthy, and peaceful, and orderly living of the people. Now, how far we are successful in this situation? Kindly see, our constitution is divided into 22 parts with the 395 articles and with the 12 schedules. Now there are 28 states and 9 union territories, coupled with 135 rules of all of this. are stakeholders or the participants in the dynamics of the Indian Constitution. Now, the nature of the Constitution, you can appreciate that governance contemplated in the Indian Constitution is a federal form of a tilt towards center. And Dr. Ambedkar has Ambedkar's statements or observations have been, this is wrong. I think, can I continue? I hope.
Sir, just for your convenience, whatever topic, whatever articles you will refer, our team will try to post it on the screen share so that
I will give the citation of the judgment.
No, citation also you can give. Our team will also post it on the chat box.
You can. No, I am referring to Kuldeep Nair versus Union of India, 2006 7 SCC, page 1. That is a citation.
The audibility is okay. Slightly internet issues from your side, it seems. Hello. Just ask Jagdish to check the internet issues at your end. Hello.
Can I proceed?
Yes, sir. Hello.
Hello.
Your network bandwidth is slightly low. It's fine.
It's fine.
It's fine.
So you are working through the mobile or the normal broadband, because bandwidth is quite low.
Hello.
So you can continue. You can continue.
There is some.
Hello.
Hello, is it audible?
Sir, it's a network bandwidth issue. It will improve with time. Hello.
So all these states, 28 states, 22 states, 28 states and 9 union territories have been held together to form a federal republic. That's the Indian Republic. And how it is acting now, what is the dynamics? Now, etymologically, the word dynamic means active, and study of are one may have to explore. For that purpose, you may kindly see the preambular concepts contained in the Constitution. That is, we are supposed to secure to all the citizens and Article 14, 15, 6.
Yeah.
Now, the topic upon which the talk is to be held is on the dynamics of the Constitution and its dynamics. Etymologically, you may kindly see the word dynamic means active, and dynamics means study of forces involved in the movement. Our Constitution is a federal constitution, and the governance contemplated is also federal, with a tilt towards the center. And that tilt towards center contemporaneously is highly advantageous because of the onslaught of the coronavirus all over the world, especially when and our Honorable Prime Minister has taken adequate steps to ward off the danger and to quell the danger insofar as our nation is concerned. So, this federal constitution means it is all the states and the union, they have been held together. Unlike in the United States, it is not coming together. Insofar as India is concerned, they are held together and they are being governed. This is the form of a federal character which we are having in our constitutional scheme, of which reference have been made to Dr. Ambedkar's speech in the judgment of the Honorable Supreme Court in Kuldeep Nair versus Union of India, which was reported in 2006-7 SCC page 1. You can refer to paragraph 50 and 51 of the third judgment on page 49. Now, in the process, how the Constitution is functioning, or to deal with the dynamics of the Constitution, one may have to see certain articles and the interplay of certain articles. These articles especially are Articles 14 to 18, which is commonly called the Equality Code, and Article 19, which deals with the freedom of speech and other freedoms, and Article 21, which deals with the right to life and personal liberty, and then the freedom of religion in Article 25 and 26. In fact, in Article 25 to 28, the freedom of religion is dealt with in our Constitution, coupled with the directive principles of state policy, and as contained in Article 51A, the fundamental duties of the citizens. Now, kindly see the period during which this nation is passing. The entire people are attacked by the virus, but the constitutional scheme affords protection to the citizenry. This is what is exactly happening. All the institutions under the constitutions are functioning in a well-oiled manner, and the federal structure or federal scheme is brilliantly working. You can see how the Prime Minister is conducting the video conferencing with all the chief ministers of the states and union territories, and devising methods and designing ways and means to alleviate the sufferings of the people all over India during this tough time. So there is a form of emergency here. What is that emergency? We may have to admit that there is a social emergency, or rather, to be more precise, a health emergency. And the government are acting under the National Disaster Management Act as well as the Epidemic Act. Now, in this context, I may raise a point for your consideration that you can see part 18 of the Constitution, which deals with the emergency provisions. And you can see Article 360 of the Constitution in part 18, which deals with First 356, provisions in the case of failure of constitutional machinery in the state, that is 356, and 360 deals with the provision as to financial emergency. Of course, there is a financially difficult situation is emerging all over the world and in India as well. But what's the sort of emergency which we are specifically undergoing? It is health emergency or a sort of social emergency. So I may suggest an amendment to the Constitution in part 18, that is, which deals with the emergency provisions, that health or social emergency, an article may have to be inserted to deal with the health and social emergency situations of the like which we are undergoing now. Coupled with that, I may also suggest an amendment to the Constitution in the Directive Principles of State Policy, which you can see in Part 4 of the Constitution, and in Article 39A of Part 4, you can see the caption is equal justice and free legal aid. What about free medical aid now? In a health emergency situation, how about extending free medical aid to poor citizens, or especially those who are below the poverty mark, BPL, to be more specific? So such an amendment can be thought of in Article 30, in the Directive Principle, in Part 4 as well. That means an amendment in Part 18 to deal with the emergency provisions, and amendment in Part 4 of the Constitutions to extend free medical aid in situations of this nature may have to be undertaken by the Parliament of India immediately after the tough period is over. This is my view to accomplish or the proper functioning of the Constitution in tough times. Now, I'm saying that it is functioning extremely well, and even without these provisions, I mean, that is provision to make a free legal aid, it is not provided in Directive Principles of State Policy, but nevertheless, the Government of India are extending all sorts of help to the poor, to the citizens of India. And the Government of India also resorting to two statutory enactments have taken care of the emergent situation that is in existence now, and by providing cash transfer, direct cash transfer, increase of food supply through PDS, because what is our aim now? Aim is right to life, not right to liberty. Kindly come to Article 21. It is right to life and personal liberty. We have restrained ourselves in view of the locking down provision. Personal liberty, to a great extent, we have given up. We are not going out. We are locked up. We have no grievance with respect to that. Our purpose, our aim is survival, that is right to life. We are asserting and we are fighting for that purpose. This is with respect to Article 21. Now kindly see Article 25 of the Constitution, which deals with the religious freedom provided in Article 25. Now, if you see Article 25 of the Constitution, right to freedom of religion, with a caption, freedom of conscience and free profession, practice and propagation of religion. And the article commences with the subject to public order, morality, and health. I went through the Constituent Assembly debates as to why, to understand, to research as to why the word health is provided there. Now kindly see why the word health is provided here. We are now understanding why the constitution makers have inserted that word health in Article 25 of the Constitution, subject to public order, morality and health, and other provisions of this part. All persons are equally entitled to freedom of conscience and right freely to profess, practice and propagate religion. This is the right conferred. So the caveats are, it is subject to public order, morality, health, and other provisions of the Constitution are entitled to freedom of conscience. What is freedom of conscience? See, earlier it is stated morality. Morality are of two kinds, public morality and private morality. And private morality has something to do with the freedom of conscience. You can have your own ideas about your religion. You can have your own means of worship. And the conscience indicate probity. Then I may tell you the meaning of those words. The three important words are there. I'll come back to that later. And now I have to concentrate on the word health. Why health is provided? I was trying to elaborate that. Now, subject to health, it is the right to propagate the religion is subjected to health.
Yeah, just right.
Yes, unmuted him. Yes, continue, sir.
Yeah.
Sorry for the interruption. And we were on Article 25 of the Constitution, which deals with the freedom of conscience, free profession, practice, and propagation of the religion. Now, in respect of this, what is meant by conscience, I was trying to elaborate. Conscience means it is a private morality, and it has got three aspects, that is, prudence, probity, and beneficence. What is meant by prudence, one may ask? It is a duty to ourselves. Prudence means duty to ourselves. And probity, it is abstaining from doing something which is harmful to others. And what is meant by beneficence, the third aspect, doing something to make others happy. Now, these three words, which comes under the word conscience used in Article 25 of the Constitution, are of utmost importance insofar as our nation's present disposition is concerned. We have got duty to ourselves, which we are performing, and we have to abstain from doing something which is harmful to others, which we are doing with a high degree of responsibility. And the third one, the beneficence, doing something to make others happy, and we are also doing our level best in that case also, in that respect also. This is my view of the situation.
General question posted in the group is, kindly repeat the three components which you have said.
Repeat.
Three components.
The three components are prudence, probity, and beneficence. Prudence, probity, and beneficence. Prudence means duty to ourselves, and probity means abstaining from doing something which is harmful to others, and beneficence means doing something which will confer some good upon others. These are the three aspects.
Thank you.
And this is the import of the word conscience, and this comes under the private morality, because each one of us are having the conscience, and we have got freedom of conscience also. So these words are cardinal, and we are now called upon by the virus which is attacking us to be prudent, to behave with probity, and to confer and to act in accordance with the beneficence, concept of beneficence. This is my view of the situation, the assessment of the situation, and the Constitution under Article 25 is functioning. And when tested, the citizenry, the 135 crores of Indian, they are responding to what is contemplated, or they are acting in accordance with the freedom conferred upon them, is my humble assessment. But I may have to deal with that word health contained in Article 25 of the Constitution, and the word propagate. To what extent you can propagate your religion? We have got, all of us are having religion, and this is subject to propagation, is subject to what you may call public order, health, and morality. There is, I have already told you, that is private morality is there, public morality is there. What is a yardstick or the principles upon which the public conduct themselves? That is the public morality. And then comes the health aspect. How the health is important, to what extent the health is important, is now evident, and for what purpose this word is provided is also evident now. And because of the religious congregation that was held in Nizamuddin, and the spread of virus in view of that. So, to what extent you can propagate your religion? First, you have to propagate your religion when the health conditions are okay, and you have to propagate religion without harming public order, without causing any detriment to the public peace. So subject to health, subject to public peace and order, and subject to morality also. That means all the three concepts which I elucidated earlier. So these things may have to be borne in mind, and one may have to interpret the word propagate also. The propagation or the propagator has to do his work within the region. He cannot go, it cannot be an extra religious propagation. He cannot do it outside his region. This is my view with respect to Article 25. And one can even think of bringing an amendment to Article 25 of the Constitution, or through a interpretative process, the word propagation can be how far, what is a field of action of the word propagation may have to be properly settled. Of course, that may get settled in the matters. Now it is pending before the Honorable Supreme Court. This is my view. Now we can go ahead and proceed to the directive principles of state policy in Part 4 of the Constitution. Kindly see Article 38 of the Constitution, which state is to secure social order and promotion of welfare of the people. And 39A, equal justice and free legal aid. 39A, I have already made my submissions, or I have already made my viewpoints very clear regarding that, which warrants a constitutional amendment for free medical aid in a emergent health situation to poor people especially. And then Article 40 deals with the organization of village panchayats. In this context, I may have to draw your attention to two parts of the Constitution which deals with municipalities, certain institutions. Those institutions are municipalities, panchayats, and cooperative institutions. And those parts are, kindly bear with me, part number 9, the panchayats, Article 243 to 243O, and part number 9A, the municipalities, Article 243P to 243 ZG, and part number 9B, Article 243 ZH to 243 ZT. Now, how these institutions are functioning now in the present day? All these institutions have pulled up their socks and are working for the betterment, to alleviate the miseries of the people, to diminish the trials and tribulations now faced by the people, the citizens of India. These are all constitutional institutions. When tested, they are rising up to the mark, and they are coming up to the mark. And one have to salute all these people when we salute our doctors who are taking care of the health of the people, who are and the nurses and the health workers, health warriors, if I may say so. Now, kindly see, moving ahead, you are coming to, I may have to take you the provision relating to Article 370 of the Constitution, that is regarding Jammu and Kashmir. To my mind, a golden substitution has been effected qua Article 370 by the Parliament recently. Now, I have to read that provision. In exercise of the powers conferred by Clause 3 of Article 370, read with Clause 1 of the Article 370 of the Constitution of India, the President, on the recommendations of Parliament, is pleased to declare that as from the 6th of August 2019, all clauses of the said Article 370 shall cease to be operative except as stated above. This is through a notification. And prior to the substitution, Article 370 read as under, that is, temporary provisions with respect to the state of Jammu and Kashmir. That temporary provision that has been deleted, that is substituted by the new Article 370, and Jammu and Kashmir has been brought to the mainstream of India through a presidential notification, that notification which I just now read to you. And presently, Article 370 reads, all provisions of this Constitution as amended from time to time without any modifications or exceptions shall apply to the state of Jammu and Kashmir. This is how it is being brought into the mainstream, national mainstream. This is to my mind, is a golden substitution effected by the President of India on the advice of the Council of Ministers, and by resorting to sub-Article 3 of Article 370, which erstwhile existed. Now, another dynamics Or another activity is certain amendments which have been brought in with respect to the Constitution. You may kindly see the Constitution 99th Amendment Act 2014. Incidentally, I may have to tell you, we have, in cricket parlance, we have hit a century, and it is not out still where the number of amendments brought to the Constitution. It is more than 100 now. Now, I may have to deal this recent amendment, Constitution 99th Amendment Act 2014, which is amendment of Article 124 of the Constitution and insertion of new Article 124A, 124B, and 124C. What was contemplated was positing a National Judicial Appointments Commission. So that is, it wanted virtually to displace the present collegium system in our Constitution. I mean, in the appointment of judges to the Supreme Court as well as to the High Court. But that has been struck down by the Supreme Court. And what is still pending to be settled is with respect to the memorandum of procedure. That matter is still pending to my mind. Another amendment which may have to be taken note of by all of you and to be appreciated is the Constitution 101st Amendment, that is insertion of Article 246A in the Constitution. That is, 246A is a special provision with respect to goods and service tax. Kindly see, goods and service tax is a tax levied across goods and services on an all-India basis, including Jammu and Kashmir. In the process, around 8 taxes levied by the central government, like excise, service tax, have been subsumed, and 9 taxes levied by state governments, like VAT and entertainment tax, that also have been subsumed into this GST, goods and service tax. And it is a marked departure from the erstwhile indirect tax regime which was prevailing in India. And to accomplish the same, kindly see, 4 enactments have been enacted. What are they? They are, wherever the central government is collecting the tax or levying the tax, for that purpose, to facilitate the same, Central Goods and Service Tax Act has been enacted. That is a CGST. And insofar as the state governments are concerned, that is, wherever the state governments are levying the tax, SGST Act has been enacted. That is the State Goods and Service Tax Act has been enacted. And wherever the union territories are levying the tax, Union Territory Goods and Service Tax Act has been enacted. That is UTGST. Now, another enactment in line is the IGST, that is the Integrated Goods and Service Tax. This is in connection with the interstate supplies of goods and services. So this in fact is uniting the nation. This is a marked departure from the erstwhile taxation regime. And this is an important dynamic act insofar as Indian Constitution is concerned. One may need. You may kindly see I am standing only at the doorstep of the Indian Constitution now, because within 1 hour I can only have a broad view of the Indian Constitution and its dynamics, and I am just lifting certain articles and certain amendments to bring to your kind notice what is the dynamics that is happening now with the Indian Constitution, how active is the Indian Constitution, how active are the institutions or the constitutional institutions under the Indian Constitution. And these enactment or this amendment, these are all the act of have been passed by Parliament for the betterment of Indian society. Now kindly see the next amendment which has been taken up by the Indian Parliament. That is a Constitution 102nd Amendment Act 2018, which inserts a new article, that is Article 338B. What is Article 338B? What does it contemplate? It contemplates the position of National Commission for Backward Classes. And the article reads, there shall be a commission for the socially and educationally backward classes to be known as National Commission for Backward Classes. You may kindly see these are all activities to accomplish the preambular concepts contained in the Constitution and to uplift the downtrodden and the backward classes all over India. And we have to wait, or we waited this number of years, more than 60 or 65 years, to bring all these amendments and to make in and put in position a National Commission for Backward Classes, a brilliant move by the Indian Parliament and the government in power. Now kindly the second next amendment, the Constitution 103rd Amendment Act 2019. It amends through that process by inserting sub-article 6 in 2 articles of the Indian Constitution. That is Article 15, a sub-article 6 is provided, inserted, and Article 16, another sub-article 6 is inserted. What is in fact Article 15 and 16? Article 15 deals with the prohibition of discrimination on grounds of religion, race, caste, or place of birth. And 16, equality of opportunity in matters of public employment. And what are these articles? What are the new insertions? You may kindly see. The new insertions are sub-article 6 in Article 15. Nothing in this article or subclause G of Article 1 of Article 19 or close to of Article 29 shall prevent the state from making any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clauses 4 and 5. So this is also an enabling provision to alleviate the distress of the people, that is economically weaker sections of the people. That's also a brilliant move taken or resorted to. A late act, but nevertheless, something has been done of late. Now kindly see the sub-article 6 of Article 16. That is, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in any economically weaker sections of citizens other than the classes mentioned in clause 4, in addition to the existing reservation and subject to a maximum of 10% of the posts in each category. So this is also expected to confer benefits upon the stakeholders in Articles 16 of the Constitution of India, who are the equality of opportunity in matters of public employment. This is how the Constitution of late, I am just bringing to your notice the activities or the actions taken under the Constitution, focusing mainly upon the economically downtrodden people, the backward classes, and all sorts of backward classes in India, and to alleviate their miseries. So these are all activities, or these are all actions under the Constitution by the constitutional institutions. Now, how, insofar as we are concerned, we the citizens are concerned, how we have to act, how we have to discharge our obligations under the Constitution. In the difficult time which we are undergoing, we should have the civic sense. If we are not having that, it is high time that we are cultivating the same. And personal hygiene as well. And to cover all these things, we should be led by the word patriotism. Then only we can do justice to our Constitution. We have been conferred with the rights and freedom. Of course, the state is duty bound to protect our rights and freedoms, but we also have duties. Kindly see the fundamental duties upon us. Part 51A, what does it state? Part 4A, Article 51A, fundamental duties. It shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions and the national flag and the national anthem. To be precise, that we should be patriotic. These are our fundamental duty, to abide by the Constitution and respect its ideals and institutions. Now comes under clause D, defend the country and render national service when called upon to do so. Kindly see the national service now being rendered by the medical community, by the medical professionals, doctors, in the situation in which we are in now. And thereby we have to do justice to ourselves, we have to do justice to the constitutional concepts and the constitutional principles. And whenever any friction arises in the matter of conferment of right or freedom, you may have to resort to the concept of balancing. Concept of balancing is a constitutional necessity. You cannot interpret any of the provisions of the Constitution to annihilate another right given by the Constitution. That is, one fundamental right cannot be resorted to decimate another fundamental right or mutilate the other fundamental right. To be precise, I may bring to a kind notice the equality code that is contained in Article 14 to 18 of the Constitution cannot be applied or interpreted in such a manner that it has got more authority on the right to freedom of religion conferred under Article 25 and 26 of the Constitution of India. And our constitution, or rather our nation, is known for its unity in diversity. And now we are united in diversity as well as in adversity. This is our situation. Thank you.
So some people have put questions on the chat box.
Yeah.
I am reading it. Amdish asks, freedom of religion should be to the extent that it should not affect the health of the citizens. Please elaborate the interlinking of religion and health. What is your call?
Religion and health are interlinked, and the religious freedom has been specifically subjected to health. Now, kindly see, in India, all the temples are closed, mosques are closed, churches have been closed. Only the essential religious ceremonies are being performed there. No pilgrims are going to the temples or to the churches or the mosques or gurudwaras, for that matter. Why? You may ask. Because of the pandemic. What does the pandemic do? It affects the health of everyone. It can invade into every person if one is not careful, if one is not vigilant, if one does not have immunity to resist the invasion. And especially the people above the age of 60 and the children, they are vulnerable. So one has to be careful. And any religious propagation or any religious activity in such situations cannot take place, and the people should be disciplined. That is why I emphasized on the civic sense and the responsibility of the people to how they are conducting themselves. Even the religious freedom, there are caveats in that, subject to public order. You cannot disturb the public order. You cannot disturb the public peace. You have to act in accordance with the morals known to this nation. There are certain moral principles, dharmas, known to this nation, which are basic and essential so far as India is concerned. How India is called in Article 1 of the Constitution, you may kindly see. What is the name of India? Kindly see India. Article 1. India, that is Bharat, shall be a union of states. That Bharat denotes the dharmas that prevailed in India. That is why that word is provided there. It has got its own culture. It has got its own discipline. So it has got its own sense of morals, moral principles. So that may have to be adhered to. That's my humble view. So you cannot, you have to act, you have to restrain yourself, and the right to freedom of religion can be controlled by the difficult period when your health is in difficult position, when you are confronted with the health emergencies, which we are undergoing now. And I may have to tell you that the Nizamuddin conference also, congregation also should not have taken place because of the rule of distance, which has been imposed. Very many measures have been adopted by the central government, but such measures have to be adhered to and accepted and obeyed by the people for the betterment of the people. It cannot be flouted. So this is my view on that.
Ritesh Khatri poses, if a doctor refuses to serve despite the applicability of ESMA, but government cannot do anything because his acts are not an ingredient of strike. So does it mean that the right of life of persons of state are being violated despite ESMA?
Can you please repeat that? If doctor is not...
It says Essential Services Maintenance Act has been imposed.
Yeah.
And doctor refuses to perform his duty just because of the fear of pandemic and being a virus that his health could be at peril. Can any action be taken against such a person?
May kindly see, everybody has to act in accordance with the conscience and the oath which he has taken. What is the oath that the lawyer is taking when he is getting enrolled as a lawyer? And what is the oath that is being taken by the doctor? So he has to act in accordance with the oath he has taken. So if he is duty bound to act in accordance with the oath which he has taken at the time of enrolling himself as a physician or a medical professional. Otherwise, he is committing some offense, to my mind. He can be booked.
In order to deal with the pandemic, such as COVID-19, in a better way, do you think health emergency should be codified like financial emergency, etc.?
Absolutely. That is why I advocated and I suggested that an amendment should be there. That is why I brought to your notice Part 18 of the Constitution, which deals with the emergency provisions. Part 18, Proclamation of Emergency 352, and effect of Proclamation of Emergency 353, 356. That is provisions in case of failure of constitutional measure in the states. And now you are sliding to the financial emergency, that is Article 360, provisions as to financial emergency. But health and social emergency are not there, and we have to make an amendment in respect of that. And I am very hopeful that such an amending provision will be inserted after 360 of the Constitution. And simultaneously, in the directive principles also with respect to Article 39A, that is equal justice and free legal aid, free medical aid also in the times of health emergency. That's my answer.
If any amendment made under Article 13, subclause 4, which is placed in the 9th schedule, then how court under which doctrine could declare it unconstitutional?
Which one?
Under Article 13.4. If any amendment is placed under Article 13.4, which is placed in the
article shall apply to any amendment of this Constitution made under Article 368. Not Article 13.4 you mentioned that reads, nothing in this article shall apply to any amendment of this Constitution made under Article 368. Now, for that purpose, 13.2 may have to be seen. State shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. But 4 is there as a caveat, and in that contextually the question has come. Can you please repeat? Can you please repeat that question?
No, that question stands at the thing. The next question is, the way the economy is moving, where does a financial emergency situation is likely to become? Hello?
Financial emergency, it is up to the call is to be taken by the central government as to a situation, as to whether a situation which warrants for the declaration of a financial emergency under Article under the relevant provisions of the Constitution. That call is to be taken by the central government by assessing all the situations, emerging situations. We are in a difficult position, and the world, there is a sense of, there is a process of deglobalization, if I may say so, that is happening now. Now, kindly see the financial situation in our country, but the RBI is extending all help. The central government is doing the best extent possible through the packages and by the money transfer and increase in, but that is the direct cash transfer and increase of food article through the public distribution system, etc. But the call will have to be taken, as I said earlier, by the central government. Let us pray that such a situation may not arise, because the central government is also contemplating of easing down the locking down situation. And in that context, only the Honorable Prime Minister is conferring with all the Chief Minister concerned on next Monday, to my mind, on 27th of April, if I am correct, subject to correction. So after May, because what is to be eased is there must be production of the, there must be agricultural activities. Why? Agricultural activities is for the purpose of production. Then after the production and the conservation of the materials, then comes the next step, the distribution. Distribution through the process of transportation. This activity will have to take place, because as I stated earlier, it is all a question under Article 21, that is right to life. And what is the fight? Fight for survival now. We have to assert our right to life. We have to live. We are not now concerned with the next limb in the Article 21, that is personal liberty. While Americans are now concerned with the personal liberty. They want to be free. Can you see the statements coming from the President of the United States, Trump? He is trying to free down and is to make declare that the life is normalized in the United States. That is what he is contemplating about. Because why? They are more concerned about their freedom rather than their existence itself. Kindly see the death rates in the United States. But nevertheless, they are concerned about the second limb of Article 21, not about the first limb. This is my view.
What is your take on the constitutionality of the state intervention on the management of temples? Can you elaborate your suggestions on social emergencies? And also elucidate on extra-religious propagation?
I would like to see those two limbs. You may kindly repeat.
First question I will repeat. There are three questions he has posed. I will read one question at a time.
Yeah.
What is your take on the constitutionality of a state intervention on the management of temples?
On the management of temples, the state cannot intervene. State has to be neutral. Because the state is secular. Why the Indian citizens, they are not secular. They are entitled to have their religion. They have got the fundamental right to have their conscience. And religious freedom is also there. State has to be neutral. State cannot take over. And the state, in fact, I'm sorry to say, has taken over only the Hindu temples, not Muslims, mosques, nor Christian churches. That's the situation. So, my take.
Can you elaborate on your suggestions on social emergency?
Social emergency, you may kindly see very many factors comes under social emergency, including health emergency. Social emergency, you may kindly see if something happens, uncontrollable situation emerges, like riots or anything of that sort, which disturbs public peace, and public are put to all sorts of hardship, then of course a social emergency is necessitated.
Kindly elaborate on extra-religious propagation.
Extra-religious propagation. Extra-religious propagation can bring disturbance in society. It will unsettle the peace of the society, and moreover, it is something unconstitutional also. You are intruding into the faith of another person, because every person is having the right of conscience. You may kindly see Article 25 for that purpose. 25, how it is worded. 25 is subject to public order. All persons are equally entitled to freedom of conscience and right to freely to profess, practice, and propagate religion. So, the freedom conferred under Article 25 are equal to all persons. Nobody is having a superior freedom or nobody is having a superior right. Everybody is having an equal right. Suppose you are propagating extra religious propagation. You are intruding into the faith of another person's, which can result in conversion, which is prohibited by the Constitution, and there are judgments to that effect available. This is my take.
Under what provision of the Constitution the amendment in the medical emergency could be incorporated?
You can incorporate under 369 to my mind. Medical emergency, you can go to article, the emergency provision 360. After 360 you can, in part 18 of the Constitution. Part 18. After Article 360.
Could religion-based news be censored since the freedom of expression is being misused nowadays?
Pardon?
Could religion-based news be censored since freedom of expression is being overused these days?
Censoring, provided it disturbs the public peace, public order, and it will have deleterious effects upon the public at large. And if it is motivated, and if it is with a nefarious attempt, then it may have to. But as a last resort, always, because freedom of expression is something fundamental.
Can Union of Government bring any amendment by which the wealth, gold, etc. lying in the temples and religious institutions be utilized for the betterment of the nation, especially in the current times?
No. That cannot be. Because the wealth of the temple is for the administrator of the temple and for the welfare of the, what you may call, the religious denomination contemplated under Article 26 of the Constitution. It can be utilized only for the purpose of the religious denomination. It cannot go outside that. It cannot be acquired. Then the state will be intruding into Article 25 and 26. I have already noted that the state has to be neutral in this with respect to these aspects.
Considering the present situation, shouldn't the state be bound to protect the citizens and provide free medical health without the economic strata?
No, no. The state is justified in making a classification there. State can make a classification. You may kindly see Equal Justice and Free Legal Aid, Article 39A, Directive Principles of State Policy, and the Free Medical Aid also. I advocated for that purpose, and I even suggested an amendment to the Constitution that free medical aid for the people who require it. You have to identify. So the financial capacity of the individual may have to be seen as to whether he satisfies the criterion or the yardstick designed and devised by the state or the authorities concerned. That is entitlement. If you are entitled, you have to be provided with. If you are not entitled, you cannot.
Impact of Section 144 vis-a-vis the rights of citizen.
Where?
Impact of Section 144 vis-a-vis the rights of citizens.
144 which section? Which
CRPC. CRPC.
Get me a CRP. Just a minute. Just a minute. And go to the next question. 144. I'll answer. Hello.
I'm coming. What are your views on the All India Judicial Services like UPSC? Would it be beneficial for the nation or not?
All India Judicial Services.
Yeah.
It can be beneficial. It can be beneficial. Young blood can be inducted and it will function well. 144. You are on 144 or 144A?
144.
Urgent cases of nuisance and apprehended danger. Power to issue order in urgent cases of nuisance and apprehended danger. That's a power conferred upon the district magistrate. Sufficient ground for proceeding. Immediate prevention of speedy and remedy desirable. The magistrate may by written order. So it is only to curb the nuisance and apprehended danger. That is, the situation has to be assessed by the respective authority concerned. And that assessment, it is a discretion of the authority, and there cannot be any indiscretion, and the discretion has to be rational and reasonable. The authority cannot act upon the ipse dixit of that authority. You have to make an assessment of the whole situation, and apprehended danger means it's a wild word, you know. Apprehended danger, you cannot dream, oh, this is going to come, so I have to issue appropriate orders, I have to invoke section 144. You cannot do that. So that proper assessment, evaluation, and admission of inputs from all sources concerned, proper inquiry, these are the watchwords before resorting to section 144. It cannot be invoked on a regulation basis. You cannot.
What is your take on the mob lynching?
Pardon?
What is your take on mob lynching?
Mob lynching has to be deprecated, condemned. Recently in Palghar, it has happened. Very sorry to say that. It should not be resorted to. Every human life is valid. You have to respect the life of other person, the liberty, right to life. What are you doing? What is your authority to indulge in such activity? This is where the civic sense is lacking. You are not disciplined. The awareness must be there. You should have that spiritual background also. Then you will not be venturing into these fields.
Sumit Jain asks, should not free medical aid be put in fundamental rights instead of directive principles? As the
it can be as a subarticle of Article 21. It can be as a subarticle of Article 21 that you are entitled, depending upon if you are satisfying certain parameters. You are entitled. It can be.
In the present scenario, when there is lockdown, whether the state can direct the schools to waive off the school fees?
Pardon. Will you please repeat?
In the present scenario of the lockdown, whether the state can direct all schools to waive off the school fees?
State can have a conference with the school authorities and evaluate the impact of a complete waiver or a partial waiver. And depending upon the evaluation, orders can be issued. And moreover, it is better that the approach and the decision is made in a consensual manner. That is, the school authorities also made to understand the plight of the parents who are expected to remit the fee. So this is a proper, after doing the proper interaction, this can be sorted out, is my view. Because the school authorities are also I'm told in some states, CBSE schools, I have read in some newspapers as well as in the television broadcast that they are not insisting for new dress for the children, because every year they used to insist for new dress. So they are not insisting for that. And the enhancement of fee will not be there. All those things they have come out. Publicly they have stated. But with respect to complete cancellation, you have to take their views also, to what extent they can accommodate that, because they may also expend, they may also incur some expenditure in the activity of conducting the school. That is why. Also, it is up to the administration to have a level-headed approach with respect to that.
Can there be reservation in the defense forces on the basis of caste?
On the basis of caste, there cannot be. Ruled out.
Police, doctors, or any professionals say that our COVID-19 warriors are doing their best, but still some miscreants are trying to make situation worse. What action can be taken against the miscreants?
That is why the new ordinance have come into place. Kindly, the central government has acted with utmost promptitude in bringing out the new ordinance yesterday or day before yesterday. They have brought out the ordinance to protect the lives of the health workers against from the activities of the miscreants, disorderly behavior of the miscreants. Hello.
Yeah, okay. Since we are running short of time, we are touching at 12:30. As we had requested you, just 5 minutes, how to assimilate knowledge, just like you, how to research law. What is your take to the young lawyers, students, and other lawyers?
Young lawyers, students, kindly my first advice is they have to take care of their health. One, by taking food on time. Usually, young lawyers, I have been seeing a lot of young students in Supreme Court. Interns also. With respect to, I used to ask them, have you taken your food? Have you taken your lunch? No, I have not taken. More often than not, the answer will be negative. Then I used to advise them, please take your food on time. Otherwise, over a period of time, you will be suffering. So first advice is to take food on time. The next advice will be, they have to learn to be patient, and they should have the perseverance. Patient for what purpose? To acquire knowledge, you have to be patient. To acquire income, also in legal profession, you have to be patient. To acquire work in legal profession, you have to be patient. So this is the second aspect of the matter. The third one is, you have to read at least one judgment of the Supreme Court or of the Honorable High Court every day before going to bed. Why? Because thereby you can acquire the legal jargon, the legal language. You can cultivate that. Legal language is very important for every student of law. So in that process, and while studying or while analyzing the judgments or while studying a case, you have to first see that you are a master on facts. Facts and dates, you should be thorough. There cannot be any doubt with respect to that. Then you have to research on law. In the matter of research on law, please see the provisions first. Take the act concern or the constitution, if it text of the constitution, then read the particular article, under which chapter that article comes, under which part that article comes, what is the import, purpose of that article, then how it can be applied here, or how the section can be applied here on the facts of the case which you are having. then only you need go to the judgments. And with respect to the judgments which you are expected to read, you have to make a special note. You have to keep a diary with you, and all the provisions, all the judgments, the gist of the judgment, the act or the particular constitutional article under which the judgment has been pronounced, all those things have to be noted. And if you are keeping those, this will become a very good reservoir for you, to which will come to your help after around 10 years or 15 years later. That's a advice which I have to give. Then learn to do yoga and some meditation also, to be peaceful. And please don't find fault with others when you are disturbed, because you are responsible for your disturbance, not others. These are my advice to youngsters.
So we are coming to an end. It was a wonderful session. After hearing you, the different facets of Constitution has been explored in a different dimension. We always had a perspective in a different way. But the session which we have attended today has given us a thought process in a different way. We never knew there are so much facets which could ordinarily be done. It is just like we have gone through every page of Constitution in a manner which could be understood. Despite the fact that we are in profession for so many years, we knew large number of aspects which were never there. Though we had a short time for 1 hour.
No, just one word before Torsa. Interjecting you with permission, I may tell you.
No, you are the master of the show.
No, yeah, you may kindly see. Please ask yourself, if any one of you have taken the text of the Constitution in your hand and sat for 3 or 4 days and started reading from preamble to the last article 395 and all the schedules, has any one of you undertaken that process? If you have not, please undertake that, because this is an advice given to me by my professor, Joseph Minatu, a triple LLD holder in my university days. Please
it is just like, I'm cutting you short. At the outset, I stated, majority of the people, though, say that they are a constitutional lawyer, but they invariably deal on Article 14, 16, 19, 21, 300, and by the end of the day, they say they are a constitutional expert. So as we are coming to an end, I will ask Puneet Sekho to give a formal vote of thanks. Puneet?
Hi, Mr. Chapter. Thank you so much. Mr. Radhakrishnan, it's been an honor and a privilege to be listening to you, and your in-depth knowledge of the Constitution as well its provisions is, we are all very inspired, and we will definitely take this into account. Read, since we have the time now to read the Constitution, that the way you've showed us to read it, the different provisions, the interplay of the various provisions with one another in the times of COVID at this point of time, and your wonderful advice that you've given to all young lawyers. We are the middle-aged lawyers. I would put myself in that category, and I'm so inspired by what you just said, and we will take that to heart as well. Thank you so much, and we would hope that you would come again to this forum and probably take up another facet of the law. And we would be, of course, very, very anxious and willing participants wanting to listen to you.
Thank you very much. Wish you well. Wish you all
very
well.
grateful.
Before we part, I'm just telling the other members that today in the evening, we are again having one interesting facet of law by the senior advocate, Mr. Siddharth Luthra, former Additional Solicitor General, do's and don'ts of the criminal trial. I would ask everybody to join. Those who have not joined the WhatsApp group, they can join the WhatsApp group. They can like the Instagram page or the Facebook page. They will have the update knowledge. Thank you, everyone. It was a wonderful session.
Thank you.
Thank you. Thank you.
Okay.
Thank you.
Thank you.